Hey everyone, Harry here to talk about Judge Chutkan's ruling in Trump's advice of counsel defense, or more precisely, in the Department of Justice's request that Trump have to put up or shut up on advice of counsel by a certain date. I think I'm loving this order by Judge Chutkan. Advice of counsel is something that, a lot of defendants try to throw around. Steve Bannon is doing it today in his Court of Appeals argument, appealing from his conviction for contempt of Congress. He's saying, my lawyer told me to do this. But there are stringent requirements to get an advice of counsel defense. And defendants are always trying to eat their cake and have it too, and not do the requirements. And the beauty of this order, and which seems like just a procedural agreement with the United States that Trump's got to come forward somewhat early, is that it will force him out of that stratagem. Okay, advice of counsel. Advice of counsel is a bit of a misnomer. What it really is it goes to intent. It's, my lawyer told me it was okay, so I thought it was okay, so I'm not criminally culpable. That's really what it means. But, it's so easy to just say that and to try to hide behind attorney-client privilege, et cetera. So the law very sensibly says, if you want to assert that defense, you're going to have to show first that you gave all the meaningful information to your lawyer, everything, because you can imagine the lawyer's going to come in and say one of two things. Either, that's not what I told him. I hedged in this way, or, I didn't tell him that. Or, yeah, I told him that, but that's because he didn't mention that he was the driver of the getaway car or whatever it was. I didn't have all the facts, so my analysis based on that. All right. So in order to have the ability to present it to the jury in the first place, you need to show you told the lawyer everything. And you you also need to waive the attorney-client privilege, and that's not just for the little snippet where the attorney tells you, okay, it's all right. You've got to basically waive everything having to do with this, because the other side here, the prosecution, has a right to disprove it. And it may be that in this, if you could have a videotape of it, say, the one exchange might seem like the lawyer's okaying it, but the whole discussion would show, all kinds of information back and forth, because look, lawyers generally do not counsel their clients to break the law. And lawyers are a hyper cautious lot who will, if anything, say, there's some risk here, but blah, blah, blah. So it's a rare event to genuinely tell a lawyer everything, and then looking at the entire course of what you said, have the lawyer cleanly advise you to break the law. So you've got to come forward with it, and it really is at that point that defendants often will close up shop. But they may try to do it sort of on the run or on the cuff, and to get out of these requirements and just to get it before the jury. And courts can be lax in requiring these threshold showings. And indeed, there's no specific requirement that you make this notice in advance, but the U.S. says, please, in this case, make him do it in order to avoid any kind of surprises or prejudice, whatever, in the event. So Chutkan says, yes, I agree. First, she makes clear you've got to introduce in evidence that you relied in good faith on the counsel's advice that the conduct was legal. Think about that for a second. How is Trump going to do that? Will he file an affidavit or something? Then he's going to have to take the stand. and be cross-examined on it and on a lot of things, etc. So first, it's going to put him in a testimonial posture. I don't think he can just, he can't put on Mark Meadows to say, oh, he told me that's what the counsel had told him. That's not good evidence. It's hearsay. So I think he's got to testify for starters. He ain't going to want to do that. And that you made full disclosure of all the material relevant facts. So, he's going to have to take the stand, and he's going to have to be subject to cross-exam. Did you tell him this? Did you tell him that? Did you tell him third? When was thing? What exactly did he say? And who's the lawyer here, by the way, for starters? Because remember, there's this ragtag group of different people who have Trump's ear at the end, but some of them, he says are his lawyers, others are not, and there's a real test for is somebody a lawyer. But, Lindsay Powell turned out to be not Sidney Powell, not his lawyer. Then they've introduced in different ways. What about Rudy Giuliani? Who's it going to be? Because that person is going to have to, testify as well. So he's going to actually have to establish a solid attorney-client relationship, and I don't think he's going to be able to do that. Oh, and one more thing. It's clear in advice of counsel, you've got to have everything. So you can't keep going down the line until you get the lawyer who will tell you the right thing, because in that case, you're not relying in good faith on the counsel, right? So you're relying in bad faith. You're just, finding the boob or crackpot who will do it. But so even if he could make all these showings as to Sidney Powell or Jenna Ellis, he still has to be cross-examined on everyone, starting with the White House counsel, Pat Cipollone, who told him otherwise. Okay, so he's got to make this threshold showing in order to get it. And very importantly, he also has to provide discovery. And this is by January 15th. So he's not just going to say, I intend, but he provides discovery of what? Any communications or evidence that he wants to use to establish a trial. And that means if he doesn't do it, I don't think he can use it at trial. And otherwise privileged communications that he does not intend to use at trial, but that are relevant to proving or undermining the advice of counsel defense in their entirety. So he's also got to turn over everything, including all the different kind of information and advice he received from counsel. Let me just say, I can't see it. I don't think it's gonna, when push comes to shove, he's not gonna be able to make the showing, and I think he's not even gonna make the threshold production of discovery. We'll see about that, but this is the sort of thing that defendants try to get away with not doing. And the great thing about this order is it forces his hand by January 15th. I do not expect a full account. He may give some stuff, but the DOJ will be able to say, wait a second, who else did he talk to? And what about, where does he show everything he told them, and et cetera, et cetera. So I think he's either going to fold up his tent, or there's going to be additional skirmishes, and they won't turn out well for him. And because she set this up in advance, that'll all be worked out before the trial. And it will keep him from basically pulling a fast one on the court with the advice of counsel defense. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.